the subject matter of Bill C-45, an act respecting cannabis, and to amend the Controlled Drugs and Substances Act, the Criminal Code, and other acts insofar as it relates to Canada's international obligations. We have been given a very tight time frame within our parliamentary calendar that we have to have a report by May 1st. So we are very grateful that witnesses have responded rather quickly to our request, understanding our dilemma. So I'm very pleased that today we have Dr. Stephen Hoffman, professor at the Faculty of Health and Osgoode Hall Law School, York University. And we are attempting, we have now, by video conference from New York, Dr. Mark Kleiman, Professor of Public Policy, Marin Institute of Urban Management, New York City. Can I test Dr. Kleiman?
He's not there yet.
Not there. Well, they did flash him, so I was hoping. All right. So I think what we will do is Dr. Hoffman will start with you in your presentation. We'll go to questions. We hope that we will be able to connect with Dr. Kleiman. And you, I understand, are following our hearings, and therefore you know our usual process. But before I get to it, I will introduce myself. I'm Raynell Andrechuk from Saskatchewan, chair of the committee. And to my right,
Senator Ngo from Ontario.
Victor O, Ontario.
Francis Lankin, Ontario.
Raymond Saint-Germain, Quebec.
Leo Cosacos, Quebec.
Steve Green, Nova Scotia.
Pat Bovey, Manitoba.
all right, Dr. Hoffman, welcome to the committee, and the floor is yours, and there will be questions, I assure you. Thank you for coming.
Great. Thank you very much for having me. It's really an honor to be here as a private individual. As mentioned, I'm a full professor of law and health at York University. And as far as I can tell, I'm the only public international law scholar in Canada who's focused on health issues. So I'm really quite pleased to be here as a resource for the committee to try to wade through the international legal dimensions of cannabis legalization. Now, I'm going to start with the bad news, in a sense, which I understand this committee heard last night, which is that the proposed legislation will clearly violate 3 UN drug control treaties that were described yesterday. But the good news is that Canada does have options, and hopefully Canada will be in a position where it could legalize cannabis, but in a way that doesn't make international law collateral damage in the process. And so today I'm just going to briefly sketch out the treaties and then talk about some of those options. They're not great options, but they exist. So for a more detailed legal analysis, I circulated an in-depth paper that I wrote with a colleague, Rujin Habibi. This paper, it's forthcoming. It's about to be published in the Ottawa Law Review. And specifically when talking about the treaties, pages 12 to 19 go in quite depth to explain exactly which provisions of the treaties will be violated by the proposed legislation. And so just in summary, which I'll share now, is that the treaty obligations are very clear. There's very little controversy around the fact that we will actually be in violation of them. To point you to just a couple of the key sections in the treaties that are implicated, I'll point you to Article 4C of the 1961 Single Convention on Narcotic Drugs, which limits drugs use, quote, exclusively to medical and scientific purposes, end quote. And then Article 36(1)(a) of that same treaty requires state punishment for their possession, production, sale, and delivery. Moving to the 1988 Trafficking Convention, Article 3(2) specifically criminalizes drugs possession, even if only for personal consumption, although I will flag that there's some language around there and loopholes in a sense, such that that particular article is not the one I personally would be most worried about. It's the others that I mentioned. Now, certainly when it comes to treaties, there's always flexibility built into a regime, and that's a good thing because every country is different. And so the flexibilities that these 3 treaties provide are numerous. One would be, for example, that it specifies that there must be state punishment for the possession, use, sale of drugs, but it doesn't specify exactly what the punishment must be. And so a country like Portugal has taken advantage of that flexibility by, instead of having criminal sanctions, that country instead has punishments like mandatory education around drugs. There's also the treaties require that states have, in law, state punishment, but the treaties do not require countries to enforce those legal provisions. So, for example, the Netherlands has taken advantage of that flexibility, where, for example, the possession of cannabis continues to be a criminal activity, but the police, and with government support, have mentioned that they won't be actually enforcing those criminal prohibitions. And third, another flexibility is there is a constitutional override. And by that, what I mean is that the treaties don't expect countries to violate their own constitutions in order to be in compliance with the treaties. So Bolivia took advantage of that flexibility by actually changing its constitution in 2009 in order to allow coca leaf to be possessed by its citizens. And there's cultural importance to coca leaf in that country. So when thinking about what options Canada has available in terms of legalizing as opposed to having a different punishment or not enforcing, there are still 5 options, 3 of which are not very good. I'll explain in a second. 1 would be we could change the Constitution. 2, we could renegotiate the treaty. 3, we could try to obtain special exceptions. And those 3, I think we can quickly rule out by just thinking of the fact that convincing the 32 countries in the world that currently have death penalties for drug smuggling to actually renegotiate the treaties or to give Canada a special exception is likely as politically feasible as adding an additional article to the Canadian Charter of Rights and Freedoms, giving Canadians the constitutional right to possess cannabis. I don't think that's realistic, and I don't think renegotiating the treaties at this point is realistic. It leaves then 2 additional options. 1 is to find a creative workaround, and the second would be to withdraw from the treaties. In terms of a creative workaround, so as I said, I'm an international lawyer. I think from a public health perspective, legalizing cannabis is a good thing, and I would try to muster as many sort of creative legal arguments I could to try to think through how could this be done in a way that doesn't violate these international law treaties. Because I'm also an international lawyer, I think we should ideally not be violating these treaties. So in my own professional work, I worked with students, and we tried to develop what we've called a scientific purposes exemption. Now, the treaties clearly in the text allow that countries can make cannabis and other drugs available if it's for a scientific purpose. And so one legal construction, we could think of this legalization effort maybe as being one big natural experiment that is assessing the intergenerational effects of cannabis legalization on people. And we could make that claim. The challenge is it would have to be real, and there is International Court of Justice jurisprudence about what constitutes a reasonable scientific purpose. There would need to be major investments in research around this, and the government's stated objectives have never mentioned to learn about the science, to advance the scientific purpose when justifying this move. So it would be difficult to make that claim in the International Court of Justice. But that's the most creative workaround that I could come up with. The more realistic option would be withdrawing, which to my mind seems the most feasible option. And I just wanted to emphasize that withdrawing from a treaty, it's not something I would usually recommend as an international lawyer, but it's far better than breaking the international law. And withdrawing from treaties is something that is allowed, it's legal, so most treaties have provisions for withdrawing. And in fact, the act of withdrawing is in some respects an act of sovereignty, just like the act of signing up to the treaty in the first place. So it's not ideal, but better than violating. The challenge with withdrawing is that we need to, as a country, we're required to give notice. And so if there was the intention to legalize cannabis by July 1st, 2018, if that was the goal, we would have needed to give notice before July 1st, 2017, so several months ago. If Cabinet today signaled its withdrawal, we wouldn't be able to legally legalize cannabis under these treaties until July 1st, 2019. Now, I always get the question, what are the consequences of violating international law? And I can argue that there's, on one hand, yes, it's our reputation that will suffer. But in my mind, the more important argument, or the more important reason why I'm passionate about international law, is that it actually is our best mechanism for solving global problems that exist today. It's not an amazing mechanism. In fact, it's actually a rather weak mechanism, but it's the best we have. And when one considers the big global challenges we face today, we are increasingly relying on other countries to follow a rules-based order. And so, as a country, we probably want to be in a position of upholding that rules-based order and actually promoting it. That's a very, that at least has been a long-term Canadian policy. And one only needs to look at the newspaper every day to see why that's so important. Now, I understand that in the context of cannabis, Canadians may not actually care about the international law when it comes to cannabis itself, but Canadians probably do care about international law when it comes to chemical weapons, when it comes to nuclear nonproliferation, nerve agents, human rights abuses, illegal trade barriers. And unfortunately, as a country, we probably can't pick and choose which international treaties to follow without encouraging other countries to do the same. And so in conclusion, I just wanted to emphasize the important role that you play in all of this. I always tell my students that international law, the practice of international law, is not what I do, and it's not what they're doing in class learning treaties. It's actually, the practice of international law is the collection of micro-decisions that take place every day in rooms like this, at committees like yours, by people like you, who are deciding every day whether international law matters enough for it to be adhered to, or whether it doesn't. So when reviewing this particular bill, C-45, you're not just reviewing its particular provisions. In a sense, Parliament is also deciding whether the international law matters and to what extent. So I'm pleased to be here as a resource to you. It's really a great honor to be here. Thank you very much for the invitation.
Thank you, Dr. Hoffman. I'm going to turn to my clerk to find out no news on our video yet. All right, so we can go to questions. Senator O first.
Thank you, Chair. Welcome, Professor. My question relates back to a little bit what you said earlier. Yesterday, Assistant Deputy Minister Godiche testified in front of this committee. He told us that withdrawing from our international treaties on drug control would be, I quote, an excessively unnecessary and detrimental steps, end quote. He also added that federal government plan to violate our obligation under these conventions. I would like to hear from your thoughts about this response. And more specifically, I want to ask you about the following. You are the editor of a report titled Reconciling Canada's Legalization of Non-Medical Cannabis with the UN Drug Control Treaties. The report concluded that Canada's current international legal obligations are incompatible with the federal government's plan to legalize the use of recreational marijuana. It furthermore recommended that the federal government use a scientific purpose exemption without having to withdraw from the Drug Control Conventions. And could you please explain to us how the report arrived at this recommendation and whether you share this view? You know, it is my understanding that you personally believe that obtaining this exemption would prove to be extremely difficult and withdrawing would be the most successful option available to the federal government. Please.
Right. Senator, thank you very much for the question. To answer your first one, I think I would want to differentiate between withdrawing from the whole drug control regime, which is established by the treaties, and I think that's maybe what the testimony yesterday was about, that if we totally removed ourselves from all international coordination on drug control, that would be unnecessary. But I think what I'm talking about is withdrawing from the treaties. And I think if Canada could withdraw from the treaties but still participate in that system, in terms of actual formal decision-making, Canada could remain an observer at the meetings where these treaties are discussed. But more importantly, it could actually still follow basically all of the provisions. It could still be in compliance, even though it's not a member of the treaty. And there's many countries that often take that approach. For example, in some countries, it's difficult to have treaties ratified by their Senate, for example, or in different places where that's required. Not the case in Canada. But it's often used where the country government says, we'll be in compliance with the treaty even though we're not legally part of it. So I think that's the distinction. And withdrawing from the treaties would then not be an overreaction. In that respect, it's simply alleviating us from the international legal obligation, which is Canada's sovereign right to do so, and still participating in the international community. So the consequences would be not great, in my opinion. In terms of the reports, thank you for bringing attention to it. That's the report that I worked with my law students to try to be as creative as we could, trying to find what's the best. We're trying to be good lawyers, right? And I was trying to train future lawyers to be creative. And so the one that we worked on was that scientific purposes exemption. Now, that report was published a year ago. And so at that time, there was still time to withdraw, but also there was still time to fund research and to make statements about how Canada was undertaking a natural experiment in order for the rest of the world to learn the best way of addressing these issues. It still could be pursued. I think it's a less convincing argument now, after an additional year of comments and explanation. And so, in that reason, I think the best option forward is to withdraw from these treaties.
So it takes a year to withdraw. That means we got to withdraw in July 1st, 2017.
That's
Correct?
in order for Canada to have legalized cannabis on July 1st, 2018. The cabinet would have need to signal the withdrawal from the treaty before July 1st, 2017.
Yeah. So if the government ram this through, so that means our international reputation on application to treaties would be damaged or convention.
I think that I think the best way forward at this moment would probably be to withdraw from these treaties, after which the government could decide whether to immediately rejoin with a reservation, because it's easier to have a reservation to treaties when you're rejoining. Very difficult to get it when you're already part of the regime. Or alternatively, Canada could choose to be a principled objector, a noisy objector on the outside, agitating for change to this regime. It's not a perfect regime. There's lots of problems. But those would be, in my mind, those are two options for after withdrawal. You rejoin or you take a principled stand.
Thank you, Professor. Thank you, Chair.
Senator Bovey.
Thank you very much for your insights. I want to come back to withdrawing and rejoining. I think that's a step that perhaps we may not be cognizant enough about. So Canada could withdraw, and it is possible to rejoin with the exception or the proviso. Can you talk about that process a little bit for us, please?
Yes, thank you for the question. In international law, when a country signs up to a new legal obligation, they're always allowed to make certain reservations to those treaties. The idea is that it was a mechanism intended to allow countries to participate in the international legal system, even if there's a very small thing in it that doesn't allow the country to otherwise be part of it. And so usually reservations aren't great in the sense that it's creating kind of a different international law for different countries. And actually, in principle, if the reservation to a treaty is too big, for example, if we say we're going to be members of the drug control treaties, but we reserve all the provisions, and we say that we're not going to, those aren't binding on us, that would be ruled as by the International Court of Justice as not allowed. But if there's a very specific thing, such as we are agreeing to all the conditions except as they're applicable to cannabis, that would be allowed under international law. The challenge, though, is that there's two ways of having a reservation. One is when you're part of the treaty, and in this case, the treaties specify that you need to have enough countries positively grant Canada the exception to that they would be requesting, which when Bolivia tried that for coca leaf, there weren't enough countries that were willing to go out of their way to give Bolivia the exception, and I don't think Canada would get it either. Where we could get it and where Bolivia got it was after Bolivia withdrew from the treaties, they then rejoined it as a new member, and at that point they flagged their reservation, and then the rules for reservation are different. Then you need enough countries to positively object to that reservation. Not enough countries positively objected, therefore in Bolivia, they're within this regime, but the reservation applies to them on coca leaf. We could do the same in Canada.
So taking this the next step, if I may, can you give me a sense of what those timeframes are? How long does it take to withdraw? And how long does it take before a country can request the opportunity to rejoin with a reservation? Obviously, I'm not a lawyer, so I need help.
No, it's a great question. Ultimately, that depends on the specific provisions of the treaties. And for these treaties, they require, it's not exactly 1 year notice. It's actually slightly more than a year and rounding to July 1st or January 1st. That's the way it lines up with the different treaties. So if Cabinet today withdrew from the treaties, that would only legally happen on July 1st, 2019. On that date, July 1st, 2019, Canada could then rejoin these treaties.
Apply to rejoin the day the withdrawal from the treaties is effective.
That's right. You
So
can
there's not
start.
a wait. So it's bang bang. It's not a waiting period.
You can, well, presumably Canada would rejoin with the reservation.
Yes.
At which
Yes,
point
yeah.
there is then a period of time when member states of those treaties are allowed to object to
And
the
we're
reservation.
talking about the 3 treaties.
We're talking about the 3 treaties. That's right.
Thank you.
Senator Lankin.
Thank you very much, Chair, and thank you very much. I appreciate you being here. Senator Beauvais pursued the questions I had. I want to take it a step further at this point in applying it directly to both the politics of and the public policy goal of and the, I guess, legal aspects, and I'd like you to sort of parse your thinking that way. If we were to follow the scenario that you just set out and suggest to the government, and it could be something that was brought forward as an observation from committees, or there may be a way of enshrining it somehow. What is the damage to our credibility to today say, the government to say, we are signaling that we are going to withdraw. We know that that won't become effective until July 2019. Our intent is to submit, and here's a copy of what we will be submitting, our application with reservation. So we are aware that this should have happened a year ago. We're doing it now, and we are aware that we will be technically in violation from whenever this actually gets going, which might be September, October of this year, for a matter of 6 months or so. What would the damage to our credibility in terms of international participation in international treaties? And I at first, I'll say I was sort of thinking, well, we could live with that, ambiguity for a period of time. It's probably not an ambiguity, and particularly when you start to talk about other treaties, international treaties, and the import of them. And this shouldn't really be treated any differently. So I'd appreciate your thinking on that.
Yeah, thank you very much for the question, Senator. So as a lawyer, I guess the ideal is that we're never breaking laws and we're never breaking international laws included. That being said, from a perspective of the rule of international law and supporting the rule of international law, it would be far better to do exactly as you suggested, to withdraw. But then signal rejoining. So what the message it would send is, yes, Canada is breaking the law, international law, but we recognize it is international law, and we recognize that international law is important, such that we're taking action as a country to get on the right side of the law. This happens, Canadians every day accidentally find themselves on the wrong side of the law, and then generally the approach is, we try to, if it's a technical issue, if it's accidental, they didn't know about it, the approach is that we allow Canadians quickly get onto the right side of the law. So that's better, although even better would be if the Canadian, or in this case Canada, didn't break the law in the first place. But yes, that's much better than...
From a legal perspective, I understand the point you're making. When I asked the question, I also asked you to take a look at the not partisan political, small p political, the reality of what the government has done by moving ahead at this point in time, and the expectation of dates, for retail outlets and the investments that are being made in the production facilities and all of those sorts of things. So, part of me is looking at this from a practical nature of what can we do now, and the option of providing notice on withdrawing and waiting a year for implementation, which is what some people will quickly move to as the ideal response, so that we're on side with international law, seems to have some other real implications in terms of jurisdictions, businesses, all sorts of things here in Canada. So those are really both important aspects, and I'm just looking for you to weigh in terms of the damage to our credibility, to take the option that signals we know we're going to be offside for a period of time, but here's how we're going to get back on side, versus waiting and being in compliance until the withdrawal takes effect next year.
From a practical perspective, I think your suggestion is a very good one. I think it would minimize damage because it sends the signal that Canada cares about international law and we're taking action to make sure that we're in compliance with international law.
And
Yes,
one last quick one. Do you have any indication that the government is considering that? The statements last night wouldn't suggest it, but the actual proposal wasn't put, I don't think, to. It was specifically on the withdrawal. Yes. So this
And they were
proposal, though,
speaking on
of the
behalf of-
withdrawal. Okay.
Yeah.
So no
I have
indication.
no insider knowledge from here's a private individual. Having heard yesterday's testimony, it was mentioned that it was announced that the government doesn't plan to take any treaty action, which I guess would include that they're not planning to do your suggestion. Yeah.
In fact, what we've received is that Uruguay isn't planning to do anything. And the question is, should we be exactly. So that was the issue. Can I just follow up a quick question with you, Dr. Hoffman? I think Senator Lankin talked about the practical. I want to talk about the fact that Canada, the authority to sign and ratify agreements is in the hands of the executive of the national government. And so these treaties have been negotiated by some government in the past and signed. There is a very thick report that the Senate did in the Human Rights Committee. We started on international human rights treaties, and this would be in the like type, where steps have to be taken in Canada to make us in compliance. Some of our conventions were simply in conformity. And so when we sit in the Legal and Constitutional Committee and some others, we say, is Canada in compliance with its international treaties? The government, and this has been a few governments, will say, we're in conformity. So that's one reason they give. The other is we have yet to fully finish our negotiations with the provinces because some of the implementation is with the provinces. In this case, if they were to withdraw, would that cause, in these three treaties, an ability or a necessity to have to talk to the provinces, or is it, in your understanding of Canadian law, within the purview of the federal government?
Certainly, the decision to be part of treaties or withdraw is within the federal government's, the federal executive's decision. Of course, in Canada, we have a strong system of federalism, and much of that power is usually exercised in consultation with provinces and territories. The specific, whether these treaties, whether it require it, I don't believe so, because if the government did decide to withdraw from the treaties but remain in conformity with the existing regime and signal to the world they'll still be in compliance with the provisions, except for on cannabis, that would mean that the existing systems would still be in place and would still work as normal. So in that respect, I don't believe that I don't believe there would be a need for additional new involvement from the provinces and territories beyond the current involvement.
So what evidence you gave before that we would withdraw, we would not be in compliance with the treaty, but we could then attempt to re-enter with a reservation. I'm going to put to you the same question that I did to the department officials. Canada has been a strong leader to put in an international order, and not all countries feel that way. So Canada's been very much an active player to form these treaties. And like our trade agreements and everything else, it's a compromise. You said they weren't the best treaties, but it's a compromise when you want to put so many disparate countries, particularly in drugs, because some, as you say, death penalty comes using marijuana, and we are going the other way. So there's all of that layering. In a very fragile international order, I mean, if you study foreign policy right now, everyone is questioning whether it'll hold together because of a lot of the key actors, large actors, violating a lot of the treaties. So to what extent do you think Canada would lose its high moral ground in negotiations? Because when you go to the UN, people rely on Canada not to put reservations in.
That's right. I think we as a country have always been advocating for multilateralism, for the rule of law, the rule of international law. I think as a country we're famous for it. I mean, if this legislation proceeds, this wouldn't, of course, be the first time that Canada is on the wrong side of an international law, but it would be one whereby we're doing it in a way that would be controversial because these treaties were negotiated. It's a compromise. And it's at a time when we probably need international more now than ever. And as you mentioned, Senator, today's climate, when we see different actors making different statements, I think the world really needs Canada and other countries to be supporting that rules-based order. And certainly that is, I think, what we've been hearing from government, which is great. I guess the key will be, if this does proceed, Canada might find it difficult to be asking other countries about nuclear weapons, asking others about chemical weapons. And I guess I know cannabis and chemical weapons are very different, but you could imagine, we might say, oh, cannabis, it's just a drug, it's just one drug. Other country would say, well, war is war, and all is fair in love and war. And so in that respect, that could be an argument for that. So, or it's just a little nuclear weapon, not a big one, just a little one. I mean, you could imagine.
And it's a defensive thing. Yes.
It's, yeah.
Been there.
Yeah. So it's one of those things where if a country like Canada has a stellar reputation for being in compliance with international law, being a champion of international law, I do worry there might be consequences along the lines that you mentioned.
So am I right that this committee might wish to attract the attention of the government to really seriously think about this and not just say it's a little thing, so that it's not the legalization of marijuana that is exclusively the problem. It's looking at our international reputation and involvement. So that may be a recommendation that there be more input into the thinking there. Strategy.
I think the key message, I guess the most key message I can probably give is that Canada can't pick and choose which international treaties to follow without encouraging other countries to do the same.
Thank you for coming. You got the exclusive hour. We want to go to a quick one because we have.
Could he expand on the position with Uruguay? Because I was under the impression that Uruguay was on its way to following Canada's example to legalize cannabis. I've understood. Well, they've done it. They've already done it.
Already done it, and they've signaled their,
So we're following them then.
I guess you can pick that up in another
Okay.
committee.
Another day, another time.
Yeah. All right. Let's say I don't think they consulted us on their decision, but I could be wrong. But I think they did it unilaterally. So thank you. It's been very helpful, and good luck to your students in pursuing these matters, which I think are very important to Canada, as we are very much part of a world dynamic and want to be there. So good luck to you and your students.
Thank you very much.
We're going to pause for 2 minutes and see if now the video is working. To see if Professor Kleiman can hear me.